Yes, Mr. Foxton.
Your Lordship sort of seen that one of the arguments that the respondents put forward in support of their interpretation of Brogson involves reference to various of the ECJ cases which use language such as the obligation on which the claim is based. And it is said that that supports the view that in what I have been calling a cumul claim situation, it is up to the claimant to choose which of the two alternative analyses it prefers and bring its claim on that basis, and then the jurisdictional selection is closed off by that choice. Now, I'm going to invite your Lordships, when looking at the cases in which that language appears, to note the context in which it appears. It surfaces in Article 5.1, when we know that the courts which have jurisdiction are not the courts in which any part of the contract falls to be performed, but the part of the contract on which the person is suing. And it is in that context that one sees this language claim is based making its first appearance. We've got a good example of that in De Blues and Boyer in the bundles, Authorities Bundle 3, tab 28 at 1921.
Paragraph?
If Lordships would look briefly, they're very short paragraphs, I'm pleased to say, from paragraphs 5 to 13. We'll see that is based language appearing in 13.
Yes. As I see.
Maybe paragraphs have got a little longer since 1976.
And disaggregated. Yeah.
My Lord, yes. Now, I caution your Lordships against attributing significance to that language when answering the very particular question posed by cumul claims, where the complaint is not really a search for a different place of performance of an obligation, but the legal characterization of contract versus tort. These cases are not addressing that question when they use the language claim is based. In the way of authorities in certain legal orders, one will often find the phrase repeated and repeated and repeated in subsequent authorities. So it is possible with an appropriate word search to garner a huge number of claim is based references from CJEU cases. But context is very important, and none of those are, we would respectfully submit, concerned with the very particular problem which arises when you have the same conduct giving alternatively contractual and tortious claims. Well, so far as the suggestion is concerned that the way in which the claimant formulates its argument in its own pleading, or whatever the jurisdictional equivalent of a pleading is in the relevant nation state, the suggestion that's determinative, I'm going to invite your Lordships, if possible in your own time, as it were, to look at the decision of the Court of Justice in Kalassa at Authorities Vol 4, tab 50, page 2321, at paragraphs 58 to 64, because there is discussion there of how far the court's inquiry at the jurisdictional phase is closed off by that which the claimant has chosen to assert. And plainly there is a balance to be drawn between, on the one hand, not turning jurisdiction hearings into trials.
So it's page 2321, paragraph
58 to 64.
Thank you. Yes, got it. Thank you very much. Right. You're asking us to read that in due course, right?
My Lord, yes, please, with a
Yep.
particular emphasis on 64.
Thank you.
Now, my Lord, the second headline argument put is this distinction that Brogsitter turns on torts which are only actionable because of a contract falling within Article 5.1 and torts which are actionable independent of any contractual relationship between the parties or any undertaking or promise falling within 5.3, even if there is a contract claim for breach of contract based on the same conduct. Now, my lord, that analysis of Brogsitter, which finds, we would say, no support in the decision itself, faces any number of difficulties as the appropriate test to determine jurisdiction in Cumul claims. There are, of course, any number of legal duties which are imposed by law on those who enter into a particular relationship. Sale of goods, implied term of title, for example, cannot be contracted out of. The relationship is voluntary, but for those who enter into it, the legal duty is not. We have drawn the same analogy here with the duties owed by directors, be they under Dutch company law, under Article 2.9 of the Dutch Civil Code in Holterman, or as we would submit the fiduciary duties imposed as a matter of law on those who assume similar offices under English law. But there are other contexts in which distinguishing between a duty which arises because of a voluntary undertaking and one which exists independently remains elusive. If I hire a removal firm to transport my property and they damage it, is that a duty which arises by reason of their voluntary assumption of the duty of bailee? Or is that the right we all have against the world not to have our property damaged by the negligence of others? The surgeon who is freely able to walk past an injured man in the street with no liability under English law, at least, different in French law, if they walk by, but who begins to attend to the individual and does so negligently. Now, is that a liability which arises by reason only of the voluntary undertaking, or is that one which involves a right of bodily integrity and the protection of the self against negligent harm, which exists generally? So it is a very elusive distinction. It is also, with respect, one which is entirely conditioned by the history and conceptual analysis of the common lawyer. The distinction is one which Professor Stevens adopts in his book Torts and Rights, distinction between rights against the world and those that arise on a voluntary undertaking. And it's a distinction he finds particularly helpful in analysing liability for pure economic loss, where obviously we do not have any generalised duty of care in tort for that kind of loss, but with different shades of metaphor, one can be voluntary undertaken or assumed. Now, that is fine in the common law, where, as we are told, one has islands of liability within an ocean of non-liability, but it is not how civilian legal systems work. Article 1382 of the French Civil Code does not have a rights-based model, but a loss and fault-based model. They do not distinguish in French law at that level between pure economic loss and other forms of loss. And therefore, to suggest that Brogsitter turns entirely upon a distinction between obligations you only come under because you voluntarily take them on and those which exist independently, whilst an arguable point of reference for the common lawyer, is simply not a viable distinction for jurisdiction, regulation, or convention being applied across civilian and common law systems. My lords, even in an English context, it would involve different claims arising from the same tort being given jurisdictional venues, depending upon the nature of the loss in question. If one were to adapt the facts of Spartan steel slightly, and have a situation where a surveyor negligently advises a company it can drill into some bit of its ground, the cable is interrupted, the melt, which is ongoing, has to be thrown away, and there is also loss for 3 or 4 other melts that could have been undertaken in the time it takes to restore the electricity supply. It has the result that the claims for physical loss would come within Article 5.3 as a tort claim. They could be brought independently, whereas those for pure economic loss would come within Article 5.1 because they are dependent upon the voluntary undertaking established in that case by the contract. Now, my lords, all of that is inimical to the sensible operation of a jurisdictional regime, And we would submit that our pragmatic interpretation of Brog-Sitter is much more easy to use, namely, can the conduct in question reasonably be regarded as a breach of contract? And Lord, the final point in this connection is this, that the two touchstones which Arcadia urge upon your lordships, the basis of claim touchstone and the type of loss touchstone, are themselves rather difficult to square with what actually happens in Brog-Sitter. There are many cases in which it would be necessary to take account of a contract for a claim in tort without the claim on the respondent's analysis being contractual in nature. The example we give, which was an example which at one stage arose on the facts of this case before strategic amendment, is if you sue one employee for inducing the breach of another employee's contract of employment, and indeed vice versa. Now, the respondents would say those are not claims that can come within Article 5.1 in that they are depend upon legal duties that exist as against the world. We're all meant not to go around inducing breach of contractual obligations. And yet there are claims where it would be absolutely essential, a priori, en principe necessary, to have regard to the contract of employment for the purpose of establishing if the claim in tort was made out. So, my lords, this is a late runner, this distinction, but it's one that simply doesn't get off the ground, either as a matter of principle or perhaps more importantly, when looking at the practicalities of operating a jurisdictional divide. Now, my lord, in terms of the objections to our approach, I'm going to deal with two of those, if I may. The first is to say, well, Arcadia's approach doesn't require the court to answer the question, is the conduct complained of a breach of contract? But the appellant's approach does. And it said, well, look, that might involve difficulty because perhaps the contract is governed by a different national law to the law of the court hearing the jurisdictional challenge. And can there really be that requisite degree of complexity that you have to answer that question at that stage? Now, my lords, the question, may the conduct be considered a breach of contract, is obviously taken straight from Brog-Sitter, para 24. So that question is inherent in both parties' analysis of Brog-Sitter. We say that is sufficient for the tort claim to come within 5.1. The respondents, I think, accept it's necessary but not sufficient. They say there is more required, hence their reading of the a priori paragraph. But they themselves require a court to answer that first question. May the breach reasonably be regarded as a breach of contract? So it raises exactly the same issues for them as for us. But their approach doesn't stop the court's inquiry at the level of contract, because, of course, the court would then have to turn round and, applying the proper law of tort, say, and is this tortious conduct only actionable because of the contract? Or is it actionable because the tort doesn't depend upon any voluntary undertaking or assumption, but is a right against the world? So we turn this point back on them. It arises to some extent on both sides' cases, but very much more on their case than on ours. My lord, secondly, there's the question of Rome 1 and 2 and the comparison between how the jurisdiction regulation treats cumul claims and how the Rome 1 and Rome 2 conventions treat them. Now, my lords, the short answer to that is that ultimately the issue of cumul claims raises different issues which requires or may require a different response in a jurisdiction context to those which are raised when determining perhaps that the proper law of the contract claim is different to the proper law of the tort claim. The very authorities the respondents rely on their choice of law argument make that very point. If one goes first of all to the base metals decision, which is in Authorities Volume 1, tab 12, it's page 1317, but if I could go to 1329.
Yes.
Lord, it's paragraph 34, where the appellants have relied before the Court of Appeal on the position so far as it pertains to jurisdiction to argue that the contract and tort claims involved where there's been a breach of obligations by a director of the obligation of reasonable skill and care should be the same. And Lord Justice Tuckey rejects that analogy, making, we submit, the correct point that the consequences of separate jurisdictions for cumulative claims are very different and much more undesirable than the prospect of separate laws. Mr. Justice Moore-Bick made a very similar point at first instance. I'll just give your lordships the reference. Volume 2, tab 10, page 1302 at paragraph 9.
Volume 2, tab.
I'm so sorry. Volume 1. I do apologise, Madam. Authorities, Volume 1, tab 10.
1302. Paragraph 9.
Paragraph 9 on 1302. Or the last couple of lines, rejecting a submission made by Mr. Briggs, relying upon jurisdiction cases. And Mr. Justice Moore-Bick says that the Article 5153 raises quite different considerations to the proper law. Now, I'm going to just give your lordships one final citation, which is the Court of Justice in Kainz versus Panterwerker, Authorities Bundle 4, at tab 49.
Yeah.
49.
Tab 49, well, it's page 2285, and it's paragraph 20. Expressly noting that the limitations of arguments made from a proper law basis when it comes to determining jurisdiction.
Right, paragraph
Paragraph 20, my lord.
20, thank you. Thank you.
So, Lord, with respect to the extensive citation of proper law materials, they are of limited utility. There is also, of course, an extra tool in the armoury of a court worried about the tort claim being governed by a different law from the contract claim, which is that Article 4.3 of the Rome II Convention on Tort would allow the court in certain circumstances to say, I'm going to depart from the normal rule because the law governing a pre-existing relationship between the parties arising from contract is the appropriate proper law in this case. That workaround is not available to courts in jurisdictional cases being asked to determine whether the cumulative contract and tort claims should be determined in the same jurisdiction or different jurisdictions.
Yep.
So, my lord, subject to the issues in relation to the employment status of the appellant, which I'm going to come back to before the close of my submissions, I was proposing to move to the second issue on the appeal, which we have called breach of fiduciary duty claims,
Yes.
but as Lord Mance noted, that simply reflects the fact that as we stand here with the judgments to date, it only arises on the breach of duty claims, but it is equally capable of arising on the conspiracy claims. My lords will have seen that one's got two scenarios here. One has claims for breach of fiduciary duty by companies which were at one stage the contractual employer of the appellants for the periods of time when the contract of employment had moved to another group company. So, the classic example, Arcadia London, which was the initial employer up until 2009 for Mr. Bosworth and 2011 for Mr. Hurley. It has claims that continue after those dates and the question is whether those fall to be treated as coming within Section 5. There's also Arcadia Switzerland, which was never a contractual employer of either Mr. Bosworth or Mr. Hurley. Now, my lords, what Arcadia say about this is, look, there's no issue of principle here in relation to group companies with a single employing entity, because it is said Mr. Bosworth and Mr. Hurley were able to choose which company employed them. Now, my lords, add to that we have two comments. The first is the question of principle, which arises, we would say cannot depend upon whether the identity within a group of the employing company reflects the preference of the employer or the preference of the employee or some shared interest the two of them have. And we do not understand the principled basis on which it said this makes all the difference. My lords, secondly, the position is much more nuanced than that bald assertion about them being able to choose their own employer suggests. There is only one Arcadia company at the start of this process in March 2006, which is the start date of the claims that are brought. That is Arcadia London. I don't think anyone can credibly suggest that Mr. Bosworth and Mr. Hurley chose to be employed by Arcadia London in preference to some other group entity when there are no other group entities at the relevant time. Their employment continues with Arcadia London up until, in the case of Mr. Bosworth, 2009, and in the case of Mr. Hurley, July 2011. It is at that stage the employment entity becomes Arcadia Switzerland. Now, at least up until those dates, when this is simply the status quo being maintained, the company that was the only company at the start enters into a contract of employment with them, and that simply continues. There's no meaningful sense in which it could be said, well, you've chosen to be employed by Arcadia London rather than Arcadia Switzerland or Arcadia Singapore. So it is really only some way into the chronology in 2009 for Mr. Bosworth and 2011 for Mr. Hurley that the argument that they have chosen to move to another employing entity gets off the ground. And we do not understand the respondents to be asking the court to draw a distinction between the claims insofar as they fall to be considered before or after those dates. In other words, there's another point which arises. There are periods of time for which all three entities have claims. And the argument that you should have chosen to enter into a contract with all three of them simultaneously for the same period, or that there's somehow an exercise of relevant employee choice by deciding not to contract with more than one entity at the same time, is, we submit, a rather unrealistic one. So, although the argument features very much at the forefront of the respondent's case on the second point, there's no principled basis for applying it. If you did have to apply it, it would involve cut-offs as at particular dates, which differ as between Mr. Bosworth and Mr. Hurley. And in any event, there is no scenario in which it can realistically be said there should have been a written contract of employment with each entity at the same time.
I thought it was common ground that no separate loss had been identified in respect of the Singaporean entity.
Is that right? My lord, that is right.
That's right. So effectively, it's not the three entities, it's London and Switzerland.
My lord, that is right. Lord, I'm sorry. Now, my lords, in terms of the issues of principle which arise, there is a helpful threefold classification in Arcadia's case.
Yep.
I'd invite your lordships to turn up.
Paragraph?
It is at paragraph 97, core, vol 1, tab 8, page 205.
Yeah.
Now, 97.1 is not live before your lordships because Mr. Justice Burton held that where fiduciary duties were owed by one of the appellants to a company which was at the relevant time the employing entity, those claims did fall within Section 5. And that is not a conclusion that the respondents have sought to challenge thereafter. Now, lurking within that decision not to challenge is a fundamental inconsistency in their case. If one takes Mr. Bosworth, for example, he was never a de jure director of Arcadia London. So the fiduciary duties he was alleged to owe Arcadia London were duties as a de facto or shadow director. But it was accepted nonetheless that while there was a contract of employment between Mr. Bosworth and Arcadia London, those claims were caught by Section 5. Now, it is, however, said that insofar as the same claims based upon de facto or shadow directorship are brought by Arcadia London after the period of employment, they are claims that don't fall within Article 5.1 because they're not dependent on a consensual or voluntary undertaking of the requisite kind, and therefore they fall within Article 5.3 rather than 5.1. Now, if that proposition is correct, then on the logic of Arcadia's case on the first point, those claims should not come within Section 5, because they're claims which, absent a contract of employment, would be within 5.3, and Arcadia tell us claims that would, absent a contract of employment, be within 5.3, stay within 5.3, and they never come within Section 5. So the paragraph 98, when this issue is rather ducked, hides within it fundamental tension between two inconsistent parts of Arcadia's case. 97.2, which both sides accept does arise, is whether claims for breach of fiduciary duty are matters relating to a contract where brought by a non-employing entity. And, my lords, on that point, Arcadia rests its distinction between claims that arise simply from an undertaking, which they say won't always fall within Article 5.1, and claims which arise from some form of consensual arrangement, even if not a contract under applicable national law, which they say do come within Article 5.1. And, my lords, if one looks at the source and nature of the obligations that my clients are alleged to owe, it's clear that they are properly characterised as consensual. We know that they had the titles of Group Chief Executive Officer and Chief Financial Officer. Those are not ex post facto descriptions. They are what they are recorded in documents as being known as at the time. The pleading against them refers to them being entrusted or invested with authority and undertaking to discharge it. We are concerned with positions occupied and relationships which existed over a very long period of time. This isn't some bare transactional voluntary undertaking, such as in Headley Burn and Heller, when at a one-off moment in time, a bank gives a reference for a customer. All of the facts relied upon here smack of a relationship in which there is consent on both sides to the assumption by the appellants of the de facto offices, the entrusting to them of responsibilities, and the duties which follow from those. And, my lords, we do submit on any view that is something that partakes of the nature of Article 5.1. The suggestion that the company law duties arising under Article 2.9 of the Dutch Civil Code in Holterman are within 5.1, but those which would follow from de facto or a shadow discharge of the same positions would be within 5.3, we would submit is not a tenable or principled distinction. And to anticipate some submissions I'll come on to in a moment, the appellants were not acting as group CEO and CFO or contracting in the name of Arcadia Switzerland out of some gratuitous and charitable intent. That is what they were being paid to do. True it is, the payment came in the form of what they were paid under their employment contract with whoever employed them at the time. But it is common ground in the statement of facts that the bonuses they received under that contract were calculated by reference to the profits made by all the group entities, not just some of them. So these were plainly services which were being remunerated, and we say provided on a consensual basis. Now, my lords, the only authority which Arcadia cite in the distinction they seek to draw between the consensual arrangement necessary for 5.1 and a pure voluntary undertaking is the judgment of Lady Justice Gloucester in Deutsche Bank and Petramina, which is in Authorities Vol 2, tab 21. My lords, it's page 1693 I wanted to go to. Paragraph 52, Lady Justice Gloucester looks at the nature of the claim, and she said, which had been brought against Deutsche Bank, and she said it wasn't based on any form of agreement. The claim is rather that DB foisted itself upon Petramina and undertook unilaterally to act as its advisor in order to mitigate its own exposure to Petramina's bonds. Now, my lords, whether that decision is right, that you characterise that type of position as Article 5.3 rather than Article 5.1, as the judge did, is not a matter that arises today. But we are very far removed from unilateral assumption of responsibilities. If the distinction, which I'm conscious appears more in other contexts, between transactional and relational contracts or nearly contracts has any significance at all, we, in this case, are very much at the relational end. This was a long-standing, ongoing, consensual arrangement with my clients discharging offices for remuneration and duties being imposed on them as a result. So, my lords, on that second question, we say plainly the fiduciary duty claims brought against Mr. Bosworth and Mr. Hurley are matters relating to contract, every bit as much for the periods when they're not brought by employing entities, as appears to be common ground, they are contractual during the periods when they are brought by employing entities. And my lords, that takes us to what I suggest is the real point on this stage of the appeal, which is, can you say the claims brought by the non-employing companies are matters which relate to an individual contract of employment? Now, it's clearly that the functions the appellants discharged for the various companies in whose name they transacted were what they were employed to do, and they are the matters for which they were paid through the contract of employment. The fiduciary duties came to an end when their employment came to an end. That's the pleaded case is that they continued up until the end of the employment contract. They are inextricably linked to the employment relationship, the employment contract between the appellants and the employing companies. And my lords, if we're not right about this, and one looks at Section 5 and the social purpose it's intended to achieve, there is a very easy way around this, which is for group companies to have a particular company of their number that is the employing entity, which then loans out those employees to act for and provide services to other companies in the group. And that is not some fanciful or hypothetical position. It is actually a very common basis, as we have seen from, for example, the Albron and Heineken case we have in the bundles, or in Semengo Turner, as to how many corporate groups structure themselves. Now, my lords, in terms of how we get from that admittedly rather bare and sparse assertion of social policy to the answer, we do rely heavily on the two English Court of Appeal authorities which have looked at contractual or employee bonus type arrangements, the first of which is Semengo Turner, and the second of which is Petter. Now, my lords, Semengo Turner is Authorities Volume 1, I think it's tab 14.
Right.
Now, I'm conscious that we have both set out quite a bit about these cases in our written cases. And I think it's fair to say the issues on this second part of the appeal have not moved on quite as significantly from the arguments before the Court of Appeal as they had on the first part. But if my lords will go to paragraph 33 of the judgment of Lord Justice Tuckey on 1380. As Mr. Schweger reminds me, these are very senior employees. One suspects that the costs of obtaining the anti-suit injunction that was successfully obtained in that case may naturally limit the class of employees who would be able to get it to those who are particularly powerful and well paid. But at paragraph 33, 4 lines up from the bottom, what Lord Justice Tuckey does is what we ask your lordships to do, which is to look at the reality of the situation without adopting an over-formalistic approach. And the court in that case held that a contractual bonus scheme between a different group company and the employee formed part of their contract of employment for Section 5 purposes, even though looked at on its own, it would not have been what in English law eyes would have constituted a contract of employment. It didn't have any provisions about where you were to work and matters of that nature. So Semengo Turner proceeds on the basis that you can look at the bonus relationship with another group company as part of the contract of employment. Now, my lords, in Petter, a slightly different approach was adopted by Lord Justice Moore-Bick, but very much to the same effect. And that is in Authorities Bundle 2. Tab 23. My lords, it's pages 19, paragraph 19 to 20 on page 1733.
Yeah.
Lords, we place particular reliance both on the substance of the relationship language at the end of para 19 and the reasoning at para 20, which wasn't that the bonus arrangement was part of the contract of employment, but that it was intrinsically bound up with it. Now, my lords, although I don't ask your lordship to go to it now, the closest the Court of Justice have come to grappling with this or similar issues, we think, is in Pugliese, which involved the slightly different issue of an employee seconded by or given permission by one employer to go and work at the premises of another employer in the construction of Eurofighter. And the question arose as to whether they could sue the Italian employer, where the employee came from, the habitual place of business, of work rather, that the employee did for the German employer. I'm just going to give your lordships the reference, but although not directly on point, it is, we would submit, helpful in considering these group of company type issues. And that is Authorities Bundle 3, tab 38, and particular paragraphs 23 to 24 on pages 2112 to 2113.
Yep.
So, my lords, in summary, we say that what we get from Semengo, Turner and Petter is a group company can be an employer, even if they are not party to what in English law terms would be seen as a contract of employment with the employee. And we say either this is a Semengo-Turner type case because the voluntary obligations entrusted to and assumed by the appellants with respect to the other group companies are part of the contract of employment from a reality and substance perspective. Alternatively, in Petter terms, they are consensual obligations which are intrinsically bound up with the contract of employment. Now, my lords, there are two issues between the parties on principal issues between the parties on this point. So far as Semengo, Turner and Petter are concerned, Arcadia say that there is the distinguishing feature of there being a contract of some kind between the entity held to be the employer and the employees, be that the bonus contract in Semengo Turner, which Lord Justice Tuckey found was part of a contract of employment, or the contract in Petter that Lord Justice Morbick found was intrinsically linked with the contract of employment. My lords, our answer to that is, provided your lordships are satisfied that there is, for Article 5.1 purposes, an obligation which is autonomously contractual, in that it arises from voluntary, assumed and entrusted relationships, that is enough. And particularly if we're having regard to reality and substance and the need to consider the social purpose of Section 5, there is no proper basis for distinguishing between one type of arrangement that would fall within Article 5.1 and a contract under national law. The second point of distinction is to say, well, they are both cases concerned with benefits, and that is true. They are both cases in which the other arrangement gave rise to the prospect of additional remuneration or bonus for the employee. But we say that there is no principal basis within Section 5 for distinguishing between arrangements with other group companies that confer a bonus or some form of health scheme or some form of benefit on the employee, and those which impose obligations on an employee, but which similarly as here become part of the meat and drink, which leads to the employee's bonus, because the bonus is calculated by reference to the performance of the entire group and not simply the employing entity. Now, my lords, that brings me to the question which featured in the course of this morning of are the appellants employees at
Yes.
all? Now, my lords, if one takes up the statement of facts and issues in the core bundle, tab 6.
Yep.
Page 73.
73.
Page 73.
Yep.
Paragraph?
Well, if we begin at paragraph 12, it's accepted and has been found they had contracts of employment with certain companies. Paragraph 13, they're answerable to the ultimate shareholders. And the point here being, my lords, that Farrowhead was the 100% shareholder of all of the companies who were suing. Which sees it at 15, they are remunerated. So the remuneration box is ticked by reference to performance of the group as a whole.
And paragraph 13 is a statement of law, isn't it?
Well, if one traces it back, I think it reflects a conclusion possibly from the judgment at first instance. I think, yeah, it's Justice Burton, of a description of the position of fact, and I'll show your lordship some of the underlying affidavit evidence that makes the point that these individuals were being required to report to representatives of Farrowhead. And they are providing services. One sees that from the statement of facts and issues at paragraph 16.
Yep.
Now, my lord, I said I would take your lordship to underlying affidavits. That is in appendix part 2. And my lords, if we go to tab 23, we have the affidavit of Mr. Paul Adams, sworn on behalf of the respondents. Mr. Adams himself is now, or at least at the time of this affidavit, was Group CEO of Arcadia. That was his title, the title that Mr. Bosworth had held before him. Now, my lords, just to pick up a number of references. For example, paragraph 102 on...
So what's the thrust of all this?
Well, the thrust of all this is to make the following point, and it's a very, very fair question at 10 to 3 with 10 minutes to go. These individuals were answerable in respect of what
Well, if
they
the
did.
point of this is to assert that in practice they took their instructions from Farrowhead, I'm speaking for myself, paragraph 13 is enough. If the point is to suggest that that's an accurate statement of company law, that's different.
Well, my lord, let me see if I can approach this.
I mean, all you're saying, as I understand what you've said so far about this, is that that's the fact. Whether it's a correct statement of company law is neither here nor there on your case.
Well, I would say that in a sense it's a plus that it is not simply company law, but it is actually also what they did. And one sees, I'll give your lordships the reference, is maybe quicker, that being asked to provide daily reports and references to Farrowhead, increasing its the intensity of its supervision. My lords, in Holterman, you had a concern that the controlling body, whichever organ it was, which was notionally the person to whom Mr. Spees was answerable, might itself be controlled by Mr. Spees. Did the so-called employee control the controller? That does not arise here, and that is a fundamentally different question from how intensively in practice did the person with the right to exercise control exercise that right. That is something that might vary between different parts of the employee's job, or frankly vary depending on the appetite or suspicion or whatever else of the controlling entity from time to time. But that cannot have the result that the individuals flip in and out of Section 5, depending upon how intensive the person to whom they are answerable and who can give them directions or instructions happens to be when exercising those powers. So
you're asking us really, whereas paragraph 47 of Holterman talks about the company's administrative body which one might expect are supposed to be a board of directors, and asked whether Mr. Spies was able to influence that body to a more of a negligible extent. It rather sounds as though you're asking us to look at the reality of this one, where the reality is it's a shareholder who controls what goes on to the extent that it isn't the CEO who controls it.
Well, Lord, yes, and also to draw a distinction between a situation in which there are rights of control, but perhaps for a senior employee, a hands-off approach is taken, or at least is taken for periods of time, because it got very far from hands-off as matters went on, which is, we say, this situation. And the situation where, in fact, because of a shareholding or the ability to control whatever the relevant organ to which the employee is notionally answerable is, there is no right of control in practical terms at all. And we say that the hare set running by the Commission in Holterman was set running in pursuit of that end, although, as we've seen when it comes back to the Dutch court, no one can really quite understand why the issue was ever raised in the first place. But that is not this case, and that is why it has been common ground throughout that Mr. Bosworth and Mr. Hurley were employees. And I could make it clear they had no equity interest in any of the...
What's been common ground is that they had contracts of employment, and the suggestion made by the Commission was that having a contract of employment may not be the same thing as being an employee for the purpose of Articles 18 to 20.
Well, the common ground went further than that, or else we would have been having this argument of were they employees for European law purposes long before today. I accept that the findings of the judge are that their contracts of employment were made, but that did have the effect that certain claims were knocked out on the basis they fell within Section 5, and that was never appealed. Now, if they weren't employees, if it wasn't common ground that they were employees, those claims should never have been knocked out. Indeed, the breach of contract claims need never have been deleted from the pleading.
Next chap down. Yeah. I mean, the affidavit goes on, paragraph 104. They were allowed considerable day-to-day autonomy.
My Lord, at that point they did, but if one moves on, for example, paragraph 115 on page 576, they're questioning Mr. Bosworth's travel and his expenses. Paragraph 117, they're coming under increased scrutiny. So,
well, this is right at the very end, yeah.
True it was that the intensity with which the right of supervision was exercised appears to have been varied over time. But, Lords, we would submit that that cannot involve moving in or out of Section 5, depending upon how the person with the power of control chooses to exercise it from time to time. And paragraph 102 on page 570 as well, reference to Farrowhead looking to improve control structures in place.
Yes. Yes.
Lords, there is no doubt that senior employees will very often have more autonomy and a stronger bargaining position than more junior employees. And that even for one employee, there may be greater autonomy in relation to one area of their activity than there is for another. But Section 5 does not depend upon either individualised assessments of that nature of, we would submit, of the employee. It's a point Lord Justice Sales makes in Petter, that employees generally have been recognised as worthy of protection as a class. And to that extent, I suppose Section 5 is one of those many provisions in the Convention that adopts a rule utilitarian rather than act utilitarian outlook.
But I suppose Holterman could be said that you do have to undertake a rigorous scrutiny of the particular relationship, but you say it's a pretty rare case when somebody who doesn't own the place is not regarded as a worker.
My Lord, I would. And with Mr. Hurley, a man who is summoned to be dismissed from all his positions but
Yes, well,
resigns,
yeah.
as a typical example. Your Lordship will just forgive me a moment. And Lords, if I can just give you the reference in the bundle to Lord Justice Sales in Petta, but,
Yes?
which is Authorities, Vol 2, tab 23, page 1744, paragraph
What?
paragraph 57.
Thank you. Yep.
My Lord, subject to any other questions your Lordships might have, those are our submissions.
Thank you very much. Thank you, Mr. Foxton. No. Mr. Eschwager?
No, my Lord.
Do a bit of it.
Lordship, just give me a minute.
Thank
while
you.
I
You'd
take-
like at least one of his.
Yes, both of them. My Lords, as my learned friend did, I too am going to address your Lordships first on the conspiracy claim and thereafter on the breach of fiduciary claim and the question of how you treat group companies for the purpose of Article 18. Your Lordships will have seen that both parties agree that the issue raised by the dishonest assistance and knowing receipt claims are the same as those raised by the conspiracy claim. Now, so far as concerns the conspiracy claim...
Sorry to interrupt at this early stage, but why is that? Arguably, the knowing receipt claim is a claim which arises entirely independently of the contractual relationship. It creates duties that would be owed by anybody who received money with the requisite notice, irrespective of his relationship with the company.
And that is why we said follows from the conspiracy claim, because that it does arise independently of any contract, as does the conspiracy claim, whereas I think the way in which this was argued below, the fiduciary duty claim doesn't. Can I, in relation to the conspiracy claim, just identify the three broad issues that we submit that this raises? It broadly follows the structure of our written case. We say first, what your Lordships have to determine is the question of the relationship between Article 5.1 and Article 18. Secondly, and I'll come back to why that matters, secondly, there is the question of characterization. That is to say, what is it that has to be characterized for the purpose of deciding whether something falls within Article 5.1 or Article 5.3 or indeed Article 18? And how is this approached in the context of Article 5.1? This presupposes that there is, as we submit, a relationship between Article 5.1 and Article 18. We will be submitting that given that the words are identical in the history of the matter, that is something which your Lordship should decide in our favour. So those are the first two, and in our respectful submissions, main issues. The third issue which arises in relation to the conspiracy case is what one makes of Brogsitter, Holterman, and Granarola, the three recent European Court of decisions. And in our respectful submission, they follow a long line of earlier cases, at least the two 5.1 cases, do Brogsitter and Granola, and are in essence no different to what came before. So as long as one has the history and the way in which this was dealt with before Brogsitter actually raises no real difficulties in terms of analysis. Holterman, again, I'll come to this in more detail when I get there. My learned friend accepts that the test that he says applies in relation to Section 5, that's the Holterman question, is exactly the same test that he says applies in relation to Article 5.1. And so if he's wrong about Article 5.1, it follows that he's also going to be wrong about Holterman. Now, when we get to Holterman, you'll see that actually Malone Friend is completely wrong in terms of how he characterises what...
Well, he only says that they're the same on the footing that he's right about both.
Of course. But he, having said that, he accepts that the one follows the other. In my respectful submission, we would say that that's exactly right, but for a reason entirely different to the one that he gives. It is because, notwithstanding what Malone Friend says, and one sees this from paragraph 32. In paragraph 32 of Holterman, the Court of Justice refers to Broxeter, and Malone Friend conceded may not be the right word, but he says as part of his submissions, what he said in paragraph 32 is relevant to all three questions. Now one has to ask yourself, if it were the case that you determine questions of Section 5 without reference to Article 5.1, why would Broxeter be relevant to the first question, the Article 18 question? The answer is because, notwithstanding what Malone Friend says, there is a relationship between Section 5 and Article 5. The language is identical. The history makes clear the relationship. Malone Friend identifies a series of points which he says take one out of the logic of that argument. I will deal with those points. They really take him nowhere. And those are my submissions. But let me expand on them just a little.
We rather gathered they were.
Can I go back to the question of the relationship between Article 5.1 and Article 18?
Yeah.
And just to be clear about what the difference between the parties is in relation to this issue, the appellants say that even if a claim is one in tort, so that it would not be a matter relating to a contract for the purposes of Article 5.1, and indeed would be characterised as a matter relating to tort, that is, as an Article 5.3 claim, and indeed would be so characterised even if the defendant happened to be in a contractual relationship with a claimant, then notwithstanding the clear authority that says a matter relating to tort cannot also be a matter relating to contract and vice versa, and that's Calfalis, and I'll take you to that, Malone Friend says a matter relating to tort can nonetheless be regarded as a matter relating to an individual contract of employment for the purposes of Article 18. And indeed, it's part of his case that the strict binary distinction, as he puts it, which exists in relation to Article 5.3 and Article 5.1, simply disappears when you get to Article 18. My respectful submission, that is, again, not right. Now, we say that it is wrong, as your lordships know. We say that if the proper characterisation of the matter is that it is one relating to tort rather than relating to contract, then the matter will not be one relating to individual contracts of employment for the purposes of Article 18. And so the first issue for your lordships, therefore, is as to the relationship, as I've said, between the test that one applies for matters relating to contract in Article 5.1 and that which one applies for matters relating to an individual contract of employment for Article 18. And that, as I've said, is because having regard to what the Court of Justice has said in Calfalis, you cannot be a tort matter and a contract matter at the same time. And if we're right about this, then subject to the issue of characterization, which is the second issue, that is to say, what is it that you characterize and what is the appropriate test for characterization? That, in our respectful submission, is fatal to my learned friend's case. It is wrong about the relationship between the two. Now, so far as concerns the question of the relationship between a matter relating to contract for the purposes of Article 5.1 and a matter relating to an individual contract of employment for the purpose of Article 18, we have, as your lordships have seen from our written case, three main points, and the first is the history of the provision. I handed up, I think your lordships have,
You did.
The earlier
Yep.
incarnations.
You did.
And can I just show your lordships, by reference to how this provision has evolved? I don't know if my learned friends have. So far as concerns the first step, that is, of course, the 1968 Brussels Convention, which your lordships have. If your lordships go to Article 5 on the second page of that.
Thank you. Yep,
The bottom of Article 5, your lordship should see a person domiciled in a contracting state may in another contracting state be sued in matters relating to contract in the court for the place of performance of the obligation in question. Now, at this stage, as we have said in our written case, there is no separate rule dealing with contracts of employment. It is simply a category of contracts covered by Article 5.1. Cannot be said, not sure it is said, that the way in which one interprets in matters relating to contract there could possibly be different depending on whether the contract was one of employment or not. The next stage in the history of this provision, we get in the original Lugano Convention, the 1988 draft, which again your lordship should have.
well, this is the other document you added up to us.
This is the other document I handed
got
up.
it, Yep,
And again, on the second page of that,
yep,
one has still on the bottom right-hand side, Article 5.
yes,
In matters relating to a contract, starting at the beginning, a person domiciled in a contracting state may, in another contracting state, be sued in matters relating to a contract in the courts for the place of performance of the obligation in question, in matters relating to individual contracts of employment. This place is that where the employee habitually carries out his work. So again, it is impossible at this stage for my learned friends to be saying that in relation to the language of in matters relating to a contract which introduces this, one has a different test applying if the contract in question is one to do with employment. The same test must apply. The change, of course, comes when you get to 2001, the Brussels regulation, where you have a new Section 5. If I can just show your lordships that's at Bundle 1, Tab 2, beginning at page 1017.
yep.
So sorry, will you just give that reference again?
Bundle 1, Tab 2 at 1017.
Yep.
That's right.
1017.
That's a bad reference. It's 1071. I'm sorry. And if your lordships have 1071, bottom left-hand corner, in matters relating to individual contracts of employment, jurisdiction shall be determined by this section. Now, it is right to say this is now in its own section. It is right to say that some additional paraphernalia, if I can put it that way, has been attached to what happens if it is a matter relating to an individual contract of employment. But the words which matter for present purposes, that is to say, the words which identify this as a separate category for jurisdiction purposes, are identical.
Was there any explanatory opinion before this 2001?
There is a report known as the Pulkar report, which we have in the bundles.
Does it say anything interesting?
Not insofar as it's dealing with the language of in matters relating to individual contracts of employment.
Okay.
I'll give your lordships a reference to that in a moment. So effectively what my learned friend's case has to be, and I should just finish the story, of course, when you get to the Lugano Convention of 2007, which is the relevant one for present purposes, which is in Bundle 1, Tab 1, Section 5 there, page 1032,
Yeah,
same language in matters relating to individual contracts of employment. So my learned friend's case has to be that whilst it is true that between 1968 and 1988, the test for a matter relating to a contract, matter relating to an individual contract of employment, was the same. That's to say, the test for the jurisdictional test relating to contracts of employment was the same as for ordinary matters relating to contract. Because it was moved to a new section, Section 5, in 2001, everything changes at that point. And in our respectful submission, my lords, there is nothing to support that at all. The closest my learned
I think
friend...
that does have to be his case. I think he says that even under the old regime, the distinction between contract and tort, which you're advancing, is not a sound one. And contract would, so to speak, swallow up tort if there was the slightest overlap.
That's a characterization question. I'll come to the next point, which is how does one characterize these in the first place? But part of his argument is to say he doesn't have to satisfy the Article 5.1 matters relating to contract test.
Well, that is certainly an alternative way of putting it, but I think his primary way of putting it would be to say, no, matters relating to contract are always a sort of priority. There's a sort of European non-commune.
He says that on the basis of Broxeter, which, as you've seen, is a case where the Court of Justice thought it was so straightforward and simply an application of a number of Article 5.1 cases before it, that it didn't need an Advocate General. And he says it notwithstanding language, in my respectful submission, which points to exactly the opposite conclusion.
Yeah, well, you'll have to...
I will come there. But at the moment, I'm just trying to establish, since the first of the points, which is the relationship between 5.1 and 18. Yeah. And that matters, as your Lordships know, because of Calphalis. Now, I don't think my learned friend took you to Calphalis, but if your Lordships just want to see what was said in Calphalis, one has that at Volume 3, tab 32, 1991. Paragraphs 17 and 18 at 1994. That has been taken as authority for the proposition that if a matter is a matter relating to contract, it can't be a matter relating to tort, and vice versa. Now, this may not be his only argument, but what my learned friend says about the history of Section 5 is that I think he does say whatever happened in the past doesn't matter, because once you move into Section 5, everything is different. And what he does is to point to, in the first place, the decision of the Court of Justice in GlaxoSmithKline. As my learned friend explained, GlaxoSmithKline, which your Lordships have at Volume 3, tab 40, page 2138, is a case in which there were two claims in different jurisdictions, and the question that arose for the court was whether the claimant could rely on the fact that one of the claims fell within Article 18 as a basis for saying, since I have a claim which falls within Article 18 within this jurisdiction, I can rely on the Article 6 provisions concerned with related claims to bring the other claim into the same jurisdiction. And the Court of Justice said you can't do that, because if you look at Section 5, you will see that Section 5 identifies what provisions of the Brussels Regulation, Lugano Conventions, should be carried with Section 5 and what are excluded. And it effectively identifies two provisions which come with or are included in Section 5, which therefore Section 5 is not exhaustive, but Article 6 was not one of them. And so the Court of Justice says, well, since Article 6 lies outside what you're told can be relevant to an employment matter, you can't rely on Article 6. And my learned friend rightly says that that was amended after it was criticised by, among others, Professor Harris. At least it was amended in relation to the Brussels Regulation, but not in relation to the Lugano Convention. But that has got nothing to do at all with the matters in relation to an individual contract of employment language. There is no change at all which is made to that. And so GlaxoSmithKline is not authority at all for saying you should treat that language as any different, just because the place in which one finds that provision has now moved. Nothing at all was done to change the substance of the rule itself. I ought just to say this, my learned friend, at least in his written document, refers to comments by Professor Merritt at paragraph 4.49 of her work, to say that once the matter has come within Section 5, the distinction between contract and tort claims doesn't matter. And she relies on something called the Heidelberg Report, which again is a document the learned friend refers to in his written document. You'll note that's at 663, page 2689, at 2899. All we would say about that, my lords, is first, in the Heidelberg Report, they cite no authority at all for this proposition. And secondly, Professor Hess, one of the three authors of the Heidelberg Report, later produces his own report in which he says exactly the opposite. He again says it matters. If you want to be within Article 18, it has to be a contract claim. If it's a tort claim, it's not within Article 18. Now, my learned friend, I think, also said it is interesting to see what has happened in relation to the other provisions which are the subject of special protection, insurance and consumers. That's to say Sections 3 and Section 4.
Sorry, what was the page of the Heidelberg report you gave us?
It begins at 2689.
What was the page you said was relevant?
2899, I think you said.
I think
mean
sorry,
2880.
2880.
2880.
2880, right, that's better.
My learned friend also says that one can see this difference in treatment if you look at the two other sections which are dealing with groups of people who require specific protection, insurance and consumers. In my respectful submission, that is a point which goes against them. Can I just show your lordships first a case called Gabriel, which you will have in the appellant's additional authorities, tab 3. Your lordships within, if you have the Gabriel authority at tab 3 of the appellant's additional authorities, go to page 110.
Yep.
Page 110
Of that bundle, it's internal page 663. I'm looking for paragraphs 32.
Yeah.
Paragraph 32, this is dealing with consumers, so I think it's section 4. Having regard to the factual background to the case and the main proceedings, the question posed must be construed as asking essentially whether the jurisdictional rules set out in the Brussels Convention are to be interpreted as meaning that judicial proceedings by which a consumer seeks an order in the contracting state in which he is domiciled and pursuant to the state's legislation requiring a mail order company established in another contracting state to pay him a financial benefit in circumstances where that company had sent to that consumer in person a letter likely to create the impression that a prize would be awarded to him on condition that he ordered goods to a specific amount, and where the consumer actually placed such an amount order in the state of his domicile without, however, obtaining payment of that financial benefit, are contractual in nature in the sense contemplated in Article 5.1 or 13.3 of the Brussels Convention, or relating to tort. Now, I should have said that the language which introduces Section 4 is very similar, if not identical, to the language which introduces Section 5. And if I can invite your lordships just to go back to Article 1, sorry, bundle, Volume 1, Tab 1, at page 1031. Volume 1, Tab 1, page 1031.
Yep.
Section 4, Article 15, in matters relating to a contract concluded by a person, the consumer. So one has say, the same or very similar language in matters relating to a contract in a separate section, in a section which is intended to provide protections to a particular class of persons. And if you look at what the Court of Justice has said in Gabriel, just towards the end of paragraph 32, where it says, you must decide whether they are contractual in nature, in the sense contemplated in Article 5.1 or 13.3, or relating to tort. Now, it plainly still sees that the distinction which exists in Article 5.1 applies to the separate section, notwithstanding that the section is there to protect people. Now, insurance is different. My learned friend, I think, referred, Your Lordships, to the insurance position. It's different because if you look at the Lugano Convention, and in particular the section dealing with insurance, Section 3, one sees that the introductory wording doesn't deal with contract at all. So unlike Section 4 and Section 5, which talks about matters relating to contracts, when you get to the insurance section, it's just in matters relating to insurance. And it's perfectly clear from some of the provisions that one finds thereunder that you can found jurisdiction in this section whether or not you are the person with the contract with the insurance company. Article 11 is an example of that. So whatever the position is in relation to insurance doesn't really assist the learned friend. But the fact that we have in Gabriel the same delineation between matters relating to contract and matters relating to tort, notwithstanding that it's in a section intended to protect people, in our respectful submission, assists us in dealing with my learned friend's point that now that this is in a section dealing with the protection of people, everything is different. So we submit that notwithstanding my learned friend is right to say it's now moved to a section which is intended to protect a class of persons, but that is not a reason why different meaning should be given to the language when dealing with the question of what is an individual contract of employment. The next point to make in relation to Section 5 is that it is, as my learned friend, I think, accepts, a derogation from Article 2. Now, it's well established, both by European authority and indeed authority within this jurisdiction, that when one is dealing with a derogation, one is required to give the provision a narrow interpretation. That is what Your Lordships held very recently in the AMT Futures case, which we have in the bundles. I wasn't going to turn it up. Volume 3, tab 27, beginning at page 1884. It's paragraph 13 at page 1890. It's Lord Hodge, but the rest of the court agreed.
Yep.
My friend says in relation to this, well, it may be a derogation, but there is another principle that applies here, which operates in exactly the opposite way, which means that notwithstanding that this is a derogation, you should construe this widely. And the principle that he seeks to rely on there is that this is in a section of the regulation which is intended to provide protection to particular persons. And again, with respect to my learned friend, that is a submission which is completely contrary to European Court of Justice authority. Can I invite Your Lordships to go to Kalasa, which we have, it's a 2015 case, volume 4, tab 50, at page 2288. That's where it begins.
We looked at this earlier. Yeah.
Different purpose.
Yep.
Now, this is, as you'll see from the front page, a consumer contract. So it's a Section 4 case rather than a Section 5 case. But again, a case where the objective of the section is to provide protections to a particular class of persons. If Your Lordships can go to paragraph 28 at page 2316.
Yep.
Paragraph 28, in that respect, it should be recalled that Article 15.1 constitutes a derogation both from the general rule of jurisdiction laid down in Article 2, which confers jurisdiction upon the courts of the member state in which the defendant is domiciled, and from the rule of special jurisdiction for contracts set out in Article 5.1, under which jurisdiction lies with the courts for the place of performance of the obligation in question. Thus, Article 15.1 must necessarily be interpreted strictly. Now, unless my learned friend is going to say that there is a difference depending on whether the protected class of people you're dealing with is a consumer as opposed to an employee, and whereas you should give narrow interpretations to the section intended to protect consumers, but that the same doesn't apply to employees, in our respectful submission, CALASA is authority for the proposition for which we contend, namely, that this is a derogation, it should be narrowly construed, and that is so notwithstanding that this is in a section intended to provide protection to a particular class of persons.
Well, does the Advocate General say anything about that?
Exactly the same thing. If I can invite you to go to page 2302, paragraphs 39 to 41 of the Advocate General. Paragraph 41. This is Advocate General Spunza. Just picking up from 39, because this is relevant to another point I think the learned friend made, at least in his written case.
Yes, it's the same thing, yeah.
Nor do I see any reason to adopt a broad or more economic interpretation of Article 15, which would run counter to the wording of that provision on the grounds that it would be necessary to protect the consumer as the weakest actor. Article 15.1 constitutes a derogation, etc. On this point, it is true, while the aim of Article 15.1 is to protect consumers, that does not imply that the protection is absolute. That provision is clearly drafted and weighs the interests of consumers against those of the person who pursues commercial or professional activities. Because it is an exception to a general rule, the provision must be applied strictly. There is another case called Engler, which I'm not sure I will take you to. If I can just give you the reference to it. It's another consumer case. It says exactly the same thing about it. That's at paragraphs 42 and 43. So it's volume 3, tab 39, page 2115, at paragraphs 42 and 43, which your lordships will find at 2134.
Yep.
The next point my learned friend makes, and it's related to the point I've just dealt with, is to say that given the protective purpose of Section 5, that is a reason why you should give this a wide interpretation and ignore all that went before about Article 5.1 and the need for this to actually be a contract claim rather than a tort claim. But in my respectful submission, that is to misunderstand the way in which these provisions, which are intended to provide protection, operate. The protection that you get from these sections arises if you fall within the sections. Once you fall within the sections, then one quite understands why one would want to give the language in those sections a generous meaning, because you're within a section which is intended to provide protection to particular people. But the same logic does not apply to expanding the scope of those sections so that they apply beyond the words which have been used to identify the particular derogation with which we're concerned. So that the fact that they're there to protect people is not a reason to expand the scope of the provision, even if that is a basis for saying that once you're in the provision, given that it's there to protect people, one has to adopt perhaps a less than that. So again, with respect to my learned friend, that argument, again, doesn't help. Nor with respect to my learned friend, and this is not a point which he pursued orally, but it is in his written case, there is a reliance that my learned friend seeks to place on what Lord Justice Longmore said about this in Alpha Laval.
Yes.
Lordships will recall that in Alpha Laval, Lord Justice Longmore said, well, Article 20, the effect of Article 20 is to mean that the employee has to be sued in his place of domicile. Since that's what Article 2 says anyway, there's no need to construe this narrowly because it's producing the same results. Well, that may be true of Article 20, but it's not true of Article 18. And in any event, so far as the employer is concerned, it doesn't lead to the same result as Article 2 would lead to. It leads to completely the opposite results. With respect, with the greatest respect to Lord Justice Longmore's reasoning, that again does not assist my learned friend here. And so where one is left in relation to what I've called the first issue, which is the relationship between Article 5.1 and Article 18, in my respectful submission, is that my learned friend can find no reason at all why, once the language is moved into a section on its own, everything that came before as to what was meant by matter relating to contract is no longer relevant. In our respectful submission, there is plainly a relationship between Article 5 and Article 18. If my learned friend cannot satisfy the characterization test that one adopts for Article 5 to establish that he is dealing with a matter relating to contract, that is fatal to his ability to come within Article 18. Just to be clear, because again, this is a point my learned friend makes in his written submission, we don't say that the way you test this is that you first look at Article 5 and then go to Article 18. It doesn't matter to us which way one looks at this, which way around one looks at it. But you know you have gone wrong if you find that something has come within Article 18 where it was not a matter relating to contract, which could have got into Article 5. Subject to your lordships, that was all I was proposing to say about the first issue, which is the relationship issue.
Thank you.
Can I move on next to deal with the second issue, which is perhaps the main issue in this case, which is the characterization issue?
Yeah.
The question of characterization of claims in order to determine if they do concern matters relating to contract. And perhaps before I get into the detail, I should just make clear what we're talking about here. For every provision in the regulation or the convention, there is a trigger test. Is this a matter relating to tort? Is this a matter relating to contract? We are told repeatedly by the Court of Justice, the European Court, that it doesn't matter whether, for national law purposes, you treat this as a matter relating to contract or a matter relating to tort. And that is because, at a European level, these words have an autonomous meaning, as does the question of what an employee have an autonomous meaning. So that the fact that something is treated as a contract for English law purposes is not determinative of whether it is a matter relating to contract for the purposes of European law.
Yeah.
So too, the fact that when one gets to French law for the purposes of Granarola, one is dealing with something which looks to us like a statute claim, again, is not determinative once one gets to the autonomous concepts of contract at a European level. But that does not mean that the pleading in the national law, how you put your case, what it is you rely on, is irrelevant. That is in our respectful submission, there is a very helpful analysis of this, or description of what is happening, by Dr. Scott in an article we've referred to. What he says is you look to the claim form. I don't know what it's going to be called in France. I don't have my own friend's knowledge of French law, or indeed what it will be called in India, Italy, Spain, or anywhere else. You look at the pleadings here, you identify the obligations which are being relied upon to support your particular claim, and then you move to the European level and you say, well, looking at the obligations which are being relied upon, having regard to our autonomous concepts of contract and our autonomous concepts of tort, and indeed even our autonomous concept of an employee, is this a contract claim or is it a tort claim? But one does look to the pleadings. Now, Dr. Scott says the reason you look to the pleadings is because that is the place where you get the data which is relevant to the process of characterization which takes place at the European level. And if, therefore, you choose to plead a claim in tort, the obligations that you're relying upon in your claim form are not ignored, as my learned friend would like them to be. You have regard to them. That is the data which you use in order to characterize at the European level whether this is a claim in contract or in tort. So that is what we're talking about when we talk about the process of characterization. It is the process of identifying the data in question and then applying the European characterization to it. The separate question is, what is the appropriate characterization test that you apply to decide whether something is indeed a matter relating to contract or a matter relating to tort? And it's on this point that my learned friends and I disagree. In fact, I think we may disagree about what it is that has to be characterized as well.
You're now concentrating on this disagreement.
Well, I'm going to deal with both, but I just want to identify what the issues are that we are dealing with here.
Okay.
The process of characterization is as I've described them. You then have to identify what is the test. What is the test that you apply to decide whether a matter is a matter relating to contract or not? I will take your lordships to a series of authorities which make it clear that where you're dealing with the question of is the same matter relating to contract, you ask yourself whether the obligation which is relied upon is contractual in nature. Contractual in nature from an autonomous European perspective, that is to say, does it involve a voluntary assumption of, let's say, responsibility? Because that is the language, it's not my language, it's not even language which is drawn from English cases, it is the language that the European Court has used repeatedly when trying to identify what it is that is contractual on a European level. So the fact, again, that something is in a statute, if the European Court regards the relationship described by the statute as being contractual on an autonomous European level, then the obligation that the statute describes will be a contractual obligation. And the fact that you have chosen to make a claim on the basis of that obligation will mean that it is a matter relating to contract.
Yeah, well.
A very short way of identifying what it is that I propose to cover.
So the question is, what is the autonomous meaning of contract?
Indeed. And again, at the outset, it is worth identifying the choice which is before your lordships. There are two.
One or the other.
It's got to be one or the other. No one is saying that matter relating to contract, and I should make this clear. From an English law perspective, you look at the language matter relating to contract and you think, well, that's pretty wide language. Indeed, that is precisely what Lord Justice Moerbeek said in Petter, and indeed in Alpha Laval, it's also what Lord Justice Longmore said. He said, well, these are very wide connecting words. With respect, they may be so from the point of view of an English lawyer, but we know, not only from the German and French versions, but this isn't an issue between my learned friend and myself. In the context of the convention and the regulation, they do not have that wide English law meaning. They are going to mean either what we submit it means, which is you look at the obligation by reference to which the claim is brought, and you say, is that contractual in nature? Or it's going to mean what my learned friend says. And what does my learned friend say? He says, the question you ask yourself is whether the claim is one which you could have pleaded as a breach of contract. Now, my learned friend can point to no authority at all. He says Broxeter helps him. I'll come to that in a moment. But we have, as my learned friend will acknowledge, dozens of cases on Article 5.1. Never has a court formulated the test in the way that my learned friend says it should be formulated.
Well, this may be the first time, Mr. Lebrunowitz.
That's if there's a reference, my lord. Hopefully, I can persuade your lordship that we don't need a reference.
So we're not going to look at all the cases.
We're not going to look. I'm going to show you some of the cases, but not all of them.
Only the helpful ones, you mean?
Well, if my learned friend can point to a case which is unhelpful to me, no doubt he would have done so.
They're in your case, are they? All?
They are.
And you'll take it, yeah.
I'm going to take your lordships to 3 of them.
Well-judged number, right.
Can I then just, let's see where I am in my notes. As I say, the only authority that my learned friend can point to, which he says supports his proposition, that the test is not to look at the obligation that you have relied upon and to characterize that, but to ask whether you could have pleaded in a different way, is Broxeter. And he only gets to that conclusion by sidelining three of the paragraphs which make up the four key essential paragraphs in which the Court of Justice expresses its reasoning. He relies on paragraph 24, but he has to effectively ignore paragraphs 25, 26, and 27 in order to make the argument that he does.
Right. So where are we going to next? Your
Can I
three
take
cases
you-
or
I was going to take you to some of the authorities which I submit assist my case. Can I first ask you to go to the OFAB decision, which is in OFAB, which is bundle 4, tab 48, at page 2267.
Thank you. Yep.
The relevant paragraphs are 33 to 36, which you will find at 2275.
Sorry, 34, 36.
So again, they proceed without an opinion from the Advocate General. Yep. There's bottom, yeah, 2275.
There does seem to have been, there was an advocate.
Yeah,
yes,
they
you're
will
right.
proceed
My
without an
lordship-
opinion.
Yeah. 2270, your lordship is right. Decided after hearing the Advocate General to proceed to judgment without an
Yep.
opinion.
Yep.
Very bold.
No, they were-
No, but he's not
opinion.
used. There's always an advocate general.
There's always an Advocate General, they just don't have an opinion from him.
227 at D, it's made clear that
You'll have to hear from the advocate general on the question whether you should hear from him
Exactly.
as well. So whether he agreed or not, it doesn't matter.
if
And we've decided we don't need to hear from him, yeah.
Right.
33,
anyway, page 2275.
yep, 33.
33. In that connection, it must be observed first that the concept
Should
of
we start at 32 or not? Sorry.
if your lordship would find it helpful. Nevertheless, it is settled case law that the term matters relating to tort delict or quasi-delict within the meaning of Article 5.3 cover all actions which seek to establish the liability of a defendant and which are not related to a contract.
So there we have the point that they're mutually exclusive.
That's the Calfilas point.
Which
You can see
is
it.
common ground, but nonetheless, yeah.
You'll get to the same answer, whichever question you ask first. Whether you agree.
I think you have to ask the contract question first.
You have to ask the contract question first.
Well, it seems to me if tort is going to be anything which isn't contract, the way in which the court seems to proceed is to ask the contract question first and say, well, this is a claim for damages and it's not a contract claim.
I mean, every claim is either a contract claim or a tort claim.
But you have to start contract. If contract, yes, end of story. If
It doesn't matter which you start with, does it? If the position is that they are mutually exclusive, you have to decide on some principle or other which this is,
But
Yeah, but you have
let's
to
say you
decide
start
it's
with
a
a
contract.
tort.
standing that it is both in English law.
That's true, but let's say you start with the tort analysis, and
You
you
could have
say,
a
well,
tort
this looks
and-
like a tort analysis. You then still have to say, but if it's a contract analysis, then it can't be a tort analysis.
you can't do it the other way around.
Yeah, is it also a contract analysis, in which case the
Which
tort
is, it can't be a
analysis
tort
becomes
analysis.
a waste of breath?
So take Headley-Byrne. Okay, Headley-Byrne, we would say, is a tort analysis. As a matter of European law, adopting the autonomous approach to contract, which is the voluntary assumption of responsibility, they would say English law regards this as a tort, but it's a voluntary assumption of responsibility. So although we started looking at it as a tort, since we think this is an autonomous contract, from the point of view of European law, it's contract rather than tort. It's a 5-1 rather than
If you
5.
have to ask the contract question first, that must be on the footing that contract is, so to speak, a higher order of obligation,
Well,
which is that may be a perfectly respectable place to start, but that's precisely the basis of the principle of non-cumul in French law, for instance.
except that French law says that if you have a contract claim, you can't bring a tort claim.
Yes.
Whereas here, the argument is not if you have a contract. Here, the argument is, you can't bring a tort claim. Here, what my learned friend says is, even if you can bring a tort claim as a matter of English law, European law doesn't stop you bringing a tort claim. It simply says we're going to treat that as a contract claim.
The French law says effectively the same, because what it's doing is saying that you've got to treat this as a contract claim. No other claim arises, because looking at this obligation, it's contract and nothing else.
That may be true in French law, but it's not true as a matter of European law.
Right.
But in English case, if you chose to sue for reasons of limitation in tort, when you could have also sued in contract, but you only sue in tort, they would say that was a contract claim.
No, they won't say it was a contract claim. If you sue in tort, and you are not relying, well, it depends upon the basis. If your argument in tort is on a voluntary assumption of responsibility, for jurisdictional purposes, it will be a contract claim.
Yeah.
As to what it is at choice of law level, I'm going to take you to some authorities which say you need consistency between the two. So one of the problems with my learned friend's analysis, he doesn't want to go this far because he sees the difficulty that it produces, is that recital 7 of both the Rome 1 and Rome 2, and indeed there's a very recent European court authority which says you have to try and produce consistent outcomes as regards choice of law and jurisdiction, and that makes perfect sense. But if my learned friend's right about jurisdiction, one of the problems with his case is it produces a dislocation between, unless choice of law is also going to go this non-communal route, and there's no suggestion that it is or has, you're going to produce a dislocation between decisions about jurisdiction and decisions about choice of law.
If you're claiming in tort on the basis of voluntary assumption of responsibility, it would be treated as a contract claim, not because you could also have sued in classic English contract on the same facts, but because although you're suing in what we would characterize as tort, it is an autonomous European concept.
I'm grateful to my lord, because that is a very important distinction.
Yeah, I think. Okay, thank you.
Can I go back to paragraphs 33?
Yes.
Picking that up. It must be observed first that the concept of matters relating to a contract within the meaning of Article 5.1a is not to be understood as covering a situation in which there is no obligation freely assumed by one party towards another. Therefore, the application of the rule of special jurisdiction provided for matters relating to a contract in 5.1a presupposes the establishment of a legal obligation freely consented to and on which the claimant's action is based. And just pausing there, your lordship sees why we formulate our rule in the way that we do. We formulate it in that way because that is what the European Court has said the position is. You look to see a legal obligation, is it one freely consented to, and is that what your claim is based upon?
Well, I can see there is obviously a verbal analogy between this analysis and the analysis in a case like Smith and Bush about voluntary assumption of responsibility in tort. But I question whether they're actually talking about the same thing, because in tort, it's a deemed assumption of responsibility. What the House of Lords was trying to do in Smith and Bush was to explain the philosophical basis on which you might recognise a duty of care in some cases and not in others, which is why they make the point it doesn't matter whether there was actually any intention to assume obligations. There was simply an imposition by the law in certain circumstances where it's thought for that reason to be just. Nothing to do with this analysis, is it?
Well, my lord may be right, but with respect, it doesn't affect my submissions. Your lordship may be right that when you're talking about tort, voluntary assumption of responsibility in the context of Smith and Bush or Hedley Byrne or wherever, doesn't quite capture what they're talking about here. I used that as an illustration, and I think there is a controversy about that. So your lordship is right to that extent as well. Some people say it should be court, and I think there's some English authority which says it should be court. But in a sense, that's irrelevant to my case. My case is simply that the way in which European law operates is to look to see if there is a legal obligation freely consented to by one person towards another, and they use a concept which, as you've seen from Granarola, is perhaps not the way we would look at it. But then in testing to see whether the claim itself is one, which comes within Article 5.1, that's to say a matter relating to contract, it says the claimant's action must be based on that legal obligation. And in my respectful submission, that is critical, a critical problem with my learned friend's submission, because he says it doesn't matter what obligation your claim is based upon. If the court thinks, as a result of expert evidence or whatever it is that it gets, that under the proper law in question, you could have pleaded it as an implied term of contract, ignore the obligation upon which it is based, and recharacterize it as a contract claim.
you'd be saying, whether you're talking about the claim as being one in fraud or conspiracy to defraud, it's not based on any voluntary assumption of a responsibility.
Precisely. But for my learned friend, and those are, with respect, perfect examples, the conspiracy, of course, is the example which we'd most like that to apply to. But for my learned friend, take deceit and fraud. A learned friend's case is that you can imply, no doubt, well, I don't know whether this is his case, but it is very likely to be the case that you can imply an obligation of honesty, not to be dishonest, into any contract. For my learned friend, deceit will always be a claim, a contract claim, as long as there's a contract into which you can imply that term. And one gets a series of anomalous results if my learned friend is right about this.
So if the existence of the contract, or what the autonomous concept of the contract, is a fundamental ingredient of your claim, then you're into contract.
I'm relying on an obligation which is contractual, then I'm into contract. The fact that there is a contract in the background, I don't think either of us say that if there's a contract in the background...
Not of a contractual obligation, contract here meaning autonomous.
Autonomous, indeed.
Which has been broken.
And that is why, although at first sight cases like Granarolo look odd, and indeed Holterman look odd, once we go back to Holterman and you see that they have decided that even in relation to the position of the director, there is a contract, albeit an autonomous European contract, as opposed to the manager position where there's an actual contract, the question of obligations which attach to that autonomous contract, the fact that it is in a statute that applies that obligation, doesn't make that an independent obligation. It makes it an obligation which is attached to that autonomous contract. And that is the difficulty.
And your autonomous contract would include, what is a unilateral assumption of responsibility? Yeah?
Well, if it's unilateral, then I'm not sure it would, if it's unilateral. I'm not sure even the European...
We don't need to decide that in this case, you say.
Well, possibly not.
I'll come back to you on that one.
To take a very simple example, if an employer had a shop and employed a shop assistant, and the shop assistant was helping herself from the till, you would say the obligation to be honest is not an obligation that's voluntarily assumed within some autonomous sense of contract. On the other hand, the appellants would say that there is a contract. The obligation not to be dishonest can be regarded as part of that web of obligations.
With respect, that is exactly right. But
The opportunity to be dishonest arose out of the contract.
Well, a learned friend would say, and indeed I think he asserted before the Court of Appeal, that on his test, all kinds of skullduggery, I think is the language that they used, or dishonesty, would become a contract claim. So extreme dishonesty, as in your example, because I could plead an implied term which said you shouldn't be dishonest, the fact that my claim is in deceit or conversion or anything else is neither here nor there. It gets recharacterized as a contract claim. Well, he would say characterized rather than recharacterized.
Well, presumably in this case also, it could easily have been alleged that pursuant to the duty to behave competently as a member of the board, the defendant must have owed the duty to draw up a pre-liquidation balance sheet in accordance with the statute.
Precisely, my lord. And one could say,
So it could have been put as a contract claim.
Could have been put, and one could say that, although that isn't the way it's put, because no one had dreamed of the argument that my learned friend had made, other than Professor Briggs, who has consistently, I think, pushed this argument. No one has been saying, as long as it's something you could have pleaded as contract, you characterize it as a contract claim, regardless of the obligation upon which you rely. And the fact that that's tortious or statutory or whatever. Can I perhaps just take your lordships to one more?
It's not just a question of what you rely on, though. It is a question of there being, independently of the contract, precisely the same general law obligation.
Well, if it didn't exist as a general law, but you couldn't bring the claim at all.
No. So it's, I see, yes.
You want to take us to one other case?
If I can just take you to one more authority.
Yeah.
Austro McKenna, which is also in the same bundle, tab 54,
Thank you.
page 2383 is where it starts. I'm going to invite your lordships to look at page 2404, where you have paragraphs 35 to 38.
Anything in the Advocate General's decision?
Yes, one has something similar. If I can show your lordships the court and the Advocate General.
Yes,
The
of
Advocate
course.
General.
35 to 38, anyway.
35 to 38. It's at 59. So picking this up at paragraph 35,
I see. It's the last sentence of 35. isn't
that's
it?
it, and 36, if you look at 36, and on which the claimant's action is based.
Yeah.
But what happens if you have a perfectly ordinary duty to avoid negligent injury to somebody else? Can you, just by putting that in tort and saying, well, I would have owed the same duty even if I hadn't been party to a contract of employment, avoid Section 5? Or the same duty would have been owed? I mean, supposing you're...
If you're asking, my lord, whether...
Supposing an employer wants to sue an employee for the employee's negligence which has injured the employer, could he simply say, I don't have to sue, I can sue in tort, the place where the injury occurred, I don't have to sue under Section 5 of the Brussels regulation at all?
If the claim is one which he can, at an autonomous European level, say is not a contractual claim, then he could do that. But the question is whether he can
Would
plead...
most such claims be based on a voluntary assumption of responsibility?
Would they not to injure somebody else by negligent driving?
That'd be a counterexample, wouldn't it? Because you don't I mean, that's an obligation you're under without having voluntarily assumed it.
Yes. Well, I was going to say, what?
Imposed, not assumed.
You haven't voluntarily assumed it. You just owe a duty not to injure people negligently. So, on that basis, can you be sued in the place where the injury occurred, for example, rather than where you're employed?
If you're yes.
If you ask somebody to get in the back of your car, though, you might be simply assuming a responsibility to them, would you?
The point about assumption of responsibility is that happens to be the English law analysis of many torts.
Yeah.
But it's not necessarily the analysis that would be applied in the law of delict in other countries. Your analysis is rather heavily centred on a particular way in which the English common law arrives at duties.
My analysis for this particular point.
Yes.
But if it were the position that the way in which I chose to plead it did not involve, from a European point of view, a contract claim, then I could sue him wherever I wanted to.
If I'm employed by you as your chauffeur and I drive you carelessly and we have an accident, could you sue me simply in tort where you wanted to, or would
in Paris?
In those circumstances, would my liability have arisen because I had voluntarily assumed responsibility for driving you in the first place under a contract? How would it work?
Well, that made, in the first place, you'd look at the obligation which has been pleaded.
What if they simply said, you drove me, Newbagger drove me, and he drove me negligently, jumped a red light, and I got seriously injured? End of story. Damages.
No, because someone would say, well, that's
the case is put, pure negligence.
Indeed. If the obligations I rely upon are obligations which are consistent with there having been a voluntary assumption of responsibility, then the fact that I choose to characterize it as tort is not going to help me. It will be a contract claim. So the court looks to see, as I say, Dr. Scott has talked about data. You look at the obligations which have been pleaded. If they are consistent with the European conception of contract, then it is a contract claim.
Yeah, but let's take the case of the chauffeur. He's habitually employed in England. He's domiciled in England. So under Section 5, he would have to be sued normally in England. But on this one occasion, his boss asked him to take him to Calais for lunch or to Paris, and on the way in France they have an accident. can the chauffeur, injuring the boss, can the boss, the employer, say, well, the tort, I'm suing in tort, and this liability exists independent of the contract, and I'm going to sue in France.
In your example, that would be a contract claim, because everything that you've described relating to the obligation, how the obligation arises.
Not necessarily in French law. Suppose you just have a provision of the French Civil Code that says every negligent driver shall be liable to his passengers for damages. Now, you don't have to ask yourself whether there's a voluntary assumption of liability and that responsibility in that situation. You just apply the code.
Well, with respect
Only
to
because
you
the
would.
common law is so much more flexible in the circumstances in which it recognises duties.
If that obligation arose by virtue of there being I'm going to call it a contract,
Yes.
then for the purpose of European law, that would be a contractual obligation.
You'd look behind the pleading and say, but there's an employment contract here. The only reason you were driving him, you were being driven, boss, by your chauffeur, was because you'd employed him as your chauffeur.
Well, take out the employment example because because this is a test which would apply to all contracts, not just employment contracts.
Yeah, of course.
So you look at the obligations which are being relied upon, and you're saying, do those obligations arise in a context in which you have, in a contractual context, an autonomous contractual contract, which is to say, have they been voluntarily assumed, the obligations? If the obligations have been voluntarily assumed, that would be a contract claim. In your chauffeur example, it would always be a contract claim.
So
Because someone
basically,
has asked another to drive him, that is a contract claim, and the obligations which attach to that, the performance of that obligation, would be contractual
so
obligations.
you ask yourself, what was the nature of the relationship which explains why the person was doing whatever it is anyway?
Well,
That
what
seems
was
to
what
follow
was
from
what
this
was the
issue.
basis upon which the obligations arose? Did the obligations arise by reason of a contract? If the obligations arose by reason of a contract, then the obligation that you're relying upon is a contractual obligation.
Was that different from asking yourself what was the nature of the relationship in the course of which the breach of duty arose?
Well, the only reason it's different is that the way in which the Brussels regulation operates is by asking yourself not about relationships, but about whether something is a contract or a tort claim. That's the only distinction I'm trying to draw.
And when the court talks about an obligation voluntarily assumed, it's using those expressions in an autonomous sense.
Exactly.
It's not talking about the same thing as the House of Lords talking about voluntary assumptions of responsibility.
No.
They may or may not coincide.
No.
It's encapsulated in paragraph 36, isn't it, in the case we've just been looking at?
Precisely. That is the paragraph that I particularly rely on.
Well, it may be that in courts, is at a convenient time has an autonomous meaning.
I think it does, but we both understand that, my lord.
Well, 10:30 tomorrow? Thank you very much. Court's adjourned.